Picture this. It's 11:14 on a Friday night. You're driving home from dinner, 1 glass of wine 2 hours ago, the kind of evening that should not cost you anything. A pair of headlights flickers behind you. Then the red and blue lights wash across your rearview mirror. Your pulse jumps before the engine even cuts. The officer walks up. His hand rests on his holster. He looks at you. And the first thing out of his mouth is, "I smell alcohol on your breath." Whatever you say next decides everything. Not the courtroom, not the breath test at the station, the next 10 seconds. Right there at the glass. Tonight, I'm going to walk you through what he's actually listening for, what the Supreme Court has said you have to do, and the exact 4 lines that take his file apart before it is ever written. We'll close with the single line he least wants to hear from you. And it isn't the one most people guess. I'm not your attorney, and none of this is advice about your case. The details shift state by state, and a local lawyer is always worth the call. But the architecture underneath every one of these stops is federal. Once you see it, you cannot unsee it. Most drivers do not understand what the law actually allows an officer to do before any arrest is even on the table. A traffic stop is not a friendly chat. In Burke reverse, McCarty, 1984, the Supreme Court held that a routine traffic stop is not custodial interrogation. Translations: nobody is going to read you your rights. There is no Miranda warning. Every word you say at the side of the road is usable against you the instant it leaves your mouth, and it does not become protected retroactively. That single ruling is why this video exists. Most people believe their rights switch on the moment they hear some version of, "You have the right to remain silent." They don't. They are already on, and they are already fragile. The next few minutes are about how not to break them. Now, there's a second half to that rule that almost nobody covers, and getting it wrong is worse than knowing nothing. Some things at the stop are mandatory. Some things are optional. Confuse the two, and you can talk yourself into an arrest or a charge you had every legal right to walk away from. Under Pennsylvania v. Mims, 1977, an officer may order you out of the vehicle, and refusing is its own charge. Your license, registration, and proof of insurance are required by statute in every state. You hand them over, you step out. You do not have to be polite, but you do have to comply. The 4 lines we are about to cover are not for those things. They are for the things that look mandatory but actually aren't. And learning which is the entire game. He says it the same way almost every officer says it. He leans down. He looks at you. "I smell alcohol on your breath. Have you been drinking tonight?" Most drivers try to split the difference. Just 1. 2 hours ago. Nothing serious. It feels cooperative. It reads as an admission. A number and a timeline go into the report in your own voice. Quantity. Clock. Evidence you handed him for free. The line: "Officer, I'm not going to answer questions, and I'd like a lawyer." Word for word. Say it calmly. Say it once. Now there's a trap inside that line, and most drivers step on it without realizing. Berghaus v. Tompkins, 2010. The Supreme Court held that staying silent is not enough. Silence does not invoke anything. If you just close your mouth and look away, he can later argue you never invoked your rights at all. You have to speak the words out loud for the protection to exist. But, and this is the part most videos skip, under the same case, the protection collapses the instant you re-engage. You deliver the perfect line, and then you add one thing to soften it. "I just had dinner. I'm not even tipsy." 1 wasted sentence, and the whole file suddenly orbits that sentence. The rule is mechanical. You say the line. Then you stop talking. Whatever he says next, silence. Whatever he asks, silence. Whatever he implies, silence. The body cam microphone never sleeps. He changes tone. He tells you to step out of the car. You step out, because Mim says you must. Then he says, "I just need you to do a few quick tests. Just follow my finger, walk in a straight line, stand on one leg. Easy stuff." Most drivers think this is the moment to prove their innocence. They try, they wobble, they fail. The line: "Officer, I'm not going to perform any field sobriety tests." Now, word for word. Don't argue. Don't explain. Don't justify it later. Here's why this matters more than people realize. The walk and turn and the one-leg stand are divided attention exercises scored by an officer looking for clues. Wobble. Early start. Arm raised for balance. 6 clues written down, filmed and entered into evidence before the tow truck arrives. Fatigue produces clues. Bad knees produce clues. Being 53 years old produces clues. Standing on the shoulder of the highway at 11 p.m. with your heart rate at 110 produces clues. A lot of channels will tell you the Fifth Amendment protects you here. It does not. In Pennsylvania v. Moniz in 1990, the Supreme Court drew the line clearly. Sobriety tests are physical evidence, not testimonial evidence. How you sound and how you move falls outside the privilege against self-incrimination. So what is your protection here? It's not constitutional. It's that the tests are voluntary in most states. Refusal is legal. But I'm going to be straight with you because half the channels making this kind of video won't be. In many states, the prosecutor is allowed to tell the jury you refused. You're trading one certain pile of clues for one argument you can dismantle on cross-examination. Most defense attorneys will tell you that trade is worth it. This is the moment he pulls a small handheld device out of his bag and says it casually. Just blow into this so we can clear this up and get you on your way. That sounds like an exit. It is the opposite. That handheld and the official machine at the station are two completely different things under two completely different laws. And confusing the two is the most expensive mistake in this entire script. The line, at the roadside only, "Officer, I'm declining the preliminary breath test." Word for word. For most adult drivers on a standard license, the roadside handheld is voluntary. In many states, its reading cannot be used at trial to prove your blood alcohol level at all. It can only be used as probable cause to arrest you. Its sole job is to generate a number, and the moment he has a number, maybe becomes an arrest. But here's the part that costs drivers their licenses for a year. Every state has implied consent. Refuse the official chemical test at the station after you have been arrested, and your license can be suspended, often longer than a conviction would have cost you. In Birchfield v. North Dakota, 2016, the Supreme Court held that states may make it a separate crime to refuse a warrantless breath test after arrest, though they generally cannot do the same for a blood draw without a warrant. So, refuse the roadside handheld, usually legal, usually advisable. Refuse the official machine at the station. That is a different decision, and one you should be making with a lawyer on the phone if at all possible. Two narrow exceptions. Commercial license holders and drivers under 21. The roadside rules are far tighter for those groups in most states. Know your status before you open your mouth. The last moment comes just before he writes the citation. He gestures at the vehicle and says it as if it's nothing. You don't mind if I take a quick look, right? That word at the end, right, is engineered. Saying nothing sounds like saying yes. The line, "Officer, I do not consent to any search of my vehicle or my person." Loud enough that the body cam catches it clearly. Say it once. The backstory is Schneckloth versus Bustamante, 1973. The Supreme Court held that consent only has to be voluntary, that police are not required to tell you that you're allowed to refuse. In plain English, the law lets him ask in a way that doesn't sound like a question. Refusing doesn't physically stop the search, and it isn't supposed to. If he has the authority to search, he's going to search anyway. But by refusing, you force him to name the authority out loud on the recording. Probable cause, smell, canine, a warrant. Whatever it is, the search is now either challengeable later or it isn't. But the door to your own consent, the easiest door of all, is closed. If he does search, you stand back. You never interfere. You never argue on the shoulder. You let the camera work, and you let your attorney work the next morning. Now let's slow down for a minute and lay out the skeleton underneath everything we just walked through. Berkmer tells you, at a routine traffic stop, no warnings are coming and nothing you say is automatically protected. You're on the clock the moment the lights come on. Berghus tells you the only way to invoke your right to silence is to say the words out loud, and the second you re-engage, the invocation collapses. Birchfield tells you the handheld at the roadside and the official machine at the station are two different decisions, and confusion between them is the difference between a clean night and a year without a license. Underneath all of them is one split. License, registration, insurance, and stepping out of the car. Mandatory. Answering questions, performing tests, blowing into the handheld, consenting to a search. Optional. 4 lines, 4 optional moments, 1 calm voice. 11 p.m. 1 glass of wine with dinner 2 hours ago. Pulled over for a cracked taillight. The wrong way. He asks if you've been drinking. You say, 1 glass. He asks you to step out and you take the tests. You wobble because it's cold and you're rattled. He pulls out the handheld. You blow. The number is 0. 04, under the legal limit. But he has a number and he has 6 clues. He asks if he can look in the car. You say, sure, I've got nothing to hide. A bottle from a party 3 months ago is still in the trunk. 2 charges. Sober all night. The right way. Same night. Same wine. Same taillight. When he asks if you've been drinking, you say, Officer, I'm not going to answer questions and I'd like a lawyer. When he asks for the field tests, you say, Officer, I'm not going to perform any field sobriety tests. When he pulls out the handheld, you say, Officer, I'm declining the preliminary breath test. When he asks to look inside, you say, Officer, I do not consent to any search of my vehicle or my person. You step out when he asks because that one is required. You hand over the documents because those are required. You stop talking because everything else is optional. Same wine, same taillight, completely different night. So which of the 4 does the officer least want to hear? Almost everyone picks the right to counsel line because it sounds aggressive. They are wrong. It is the handheld breath test. Every other line takes away a description, a story, a wobble, a suspicion. The handheld line takes away a number, and a number is the only thing in the file a prosecutor never has to argue for. Jurors trust numbers the way they trust nothing else. That is exactly why officers offer it as a favor. It'll clear this up. We'll get you on your way. He is not helping you. He is using you to generate the one piece of evidence that quietly closes the door on every reasonable doubt. Here is what to take with you tonight when you drive home. When he asks if you've been drinking, you're not going to answer questions, and you'd like a lawyer. When he asks you to perform field tests, you're not going to perform them. When he pulls out the handheld at the roadside, you are declining the preliminary breath test. When he asks if he can take a look inside, you do not consent to any search. Say them calmly. Say them once. Then stop talking. If this was useful, hit subscribe and drop in the comments which of these you would have gotten wrong before watching this. The honest answers help more drivers than the confident ones do. Stick around. The next breakdown I'm doing is on what happens after the arrest. The booking room, the bond hearing, and the specific moment most people waive their rights without realizing it. Different law, different lines. See you there.